Your Honor.
Good morning. And would you like to, well, first, your name for the record?
Adam Tabrouge, Bradenton, Florida, on behalf of the appellant, and requesting to reserve 5 minutes.
5 minutes? Thank you, sir. You may proceed.
Your Honors, in this case, the appellant is serving a prison sentence based upon a 5-count information. I think it would be most helpful to the court if we deal with perhaps the easiest one first, which is count 1, use of a computer to solicit a child for sexual activity. It's our contention in this appeal that that count should be vacated as violative of double jeopardy principles. I know that Your Honor and that Judge Sleet previously sat just earlier this year on an opinion which I believe is identical to this one. And so I am requesting that the court vacate the conviction that was entered in count 1, and I'm requesting that the entire case be remanded for resentencing if the court agrees with that position. Count 2, other than the fact that it has the double jeopardy connection to count 1, count 2 is not a subject of an appeal in this case.
The traveling to seduce, solicit, entice a child?
That's right, Your Honor. There's no specific attacks as to count 2 before you this morning. So that leads us to count 3, which is the charge of attempted sexual battery on a person under the age of 16. And just to remind you of the procedural posture of the case, the appellant below had filed a motion to dismiss count 3 pursuant to Rule 3.190C4. And when the motion was called for hearing, the trial court, over objection, allowed an oral traverse.
Help me out in terms of the sequence. The motion to dismiss was filed, and as I understood, at the beginning there was a hearing, and the state, and then you, I don't know if you, were you, I don't think you were not trial counsel, that's correct. Then trial counsel indicated, Judge, we also have another motion to dismiss, and what the court said, because the state said, well, we're not prepared, the court said, well, in an abundance of caution, let's have it all heard at the same time. Continue for 2 days, I believe?
Yes, ma'am.
So 2 days later, trial counsel brings this motion for argument. The state still has not filed the written traverse, and that's the sequence, correct?
That's exactly right.
All right.
And it was at that second hearing that the trial court then suggested that the assistant state attorney swear to certain facts.
And before we get to that, when it became evident that the state had not filed a written traverse, did the state at that point make a request for a continuance in order for them to do so?
At best, it would be characterized as a half-hearted motion for continuance.
Okay, and that's what I was trying to find out, because the record reflects that the state said something, and then I believe trial counsel for the defense said, you know, Judge, let's just proceed. Let's not continue this. Am I understanding the factual scenario correctly?
You are. Trial counsel for the appellant objected to a continuance, and I think he was hoping that the trial court would rule simply on the merits of the motion as presented. And it seems to me that it was actually the trial judge who came up with the idea that he would allow the...
It's rather clever, but is that really appropriate under the rules?
It's not, Judge, and there's a long line of Florida cases saying that traverses must be in writing, specific, and filed in advance of the hearing.
I'm just wondering, do we need to reach that issue here? I mean, if you look, at least with respect to the sufficiency of the attempt, right? Because if you look at what the trial judge did, he really relied on the travel and on the texting of the sexually explicit photograph, both of which I think are contained within the allegations of the motion to dismiss. Now, the trial judge may be right or wrong about whether that's sufficient as overt act. But if he's right about that, do we need to reach the issue of whether or not the oral traverse was permissible?
Well, I believe that you do, Your Honor, and because it's my position that what actually ends up happening is he relies upon all of these extraneous facts that are put forward by the assistant state attorney. And it is my position that the motion as filed was sufficient. And just to remind you, there were actually two separate motions to dismiss filed with respect to count 3.
Yeah, and I was asking solely about the
Overt
motion
act.
directed to the sufficiency of attempt, yeah.
Yes, sir. And so we could talk about that for a moment. When I've been looking at the cases on attempt and overt act, I would suggest that the mere fact that somebody traveled to a location is not sufficient to establish that an overt act occurred. And then secondly, we really don't have any evidence of what the appellant's intent was, except for the discussion of the assistant state attorney below. But in the other cases, what the trial court actually has...
Couldn't you infer intent from the photograph you saw?
Can you infer intent to engage in sexual intercourse? I don't think that you can.
Well, let me ask you that question, because it's clear from the motion, we draw all conclusions in favor of the state in every reasonable inference. The charging document charges all 5 counts, attempted lewd and lascivious battery on a minor, 16 years or younger. And then your motion seems to concede she's a minor. Your motion concedes that he was asked to send a photograph of his penis. Now, he didn't just send a photograph of his penis. It was like, let me show you that I am a willing and able buyer here. Let me show you that I have the ability, like the attempt is a present ability to do something. I think the nature of this photograph, one could argue, demonstrates the present ability to be able to do the intended act. Would it not?
With respect to the present ability, Your Honor, those are part of the extraneous facts recited by the assistant state attorney.
But your motion indicates that the detective asked him to send a photograph of his penis, which he did do. So that's your motion in and of itself, despite what the state responds to. I'm looking at the motion itself. I think you have to concede that he complied with that request. And I think that below, and you weren't below, but Mr. Britt concedes that it was an erect penis as opposed to flaccid. So does that not make a difference?
It all possibly makes a difference, Your Honor.
Okay, so now we're at the motion to dismiss stage.
Yes, sir.
We're not at a JOA. We're not at the sufficiency. And you know, in a motion to dismiss, the state does not have to prove the case or any evidence to sustain a conviction. So help me out at that stage. Why isn't that enough?
Your Honor, I think initial question is, in and of itself, was the motion to dismiss sufficient? That it did state a cause of action, for lack of a better term. And I believe that it did. Mr. Britt's allegation is all that you have is that he sent this photograph and that he traveled to a location. And that doesn't show anything other than mere preparation. And so at this point, the burden then shifts to the state to rebut those allegations, if the motion is sufficient. And that's when they begin reciting this whole long litany of additional facts that honestly should have been submitted in writing in advance of the hearing. And that's why I think he's prejudiced by the oral traverse that occurred in this case.
I don't know what the difference is between that photograph and the nature of that photograph with bringing lubricants or chocolates or flowers. Because that photograph,
It's pretty descriptive.
it shows and it means that I am ready to consummate this act. What else does that photograph mean?
Well, Judge, it actually can mean a whole variety of things based upon popular culture from what we hear. But
this is to a minor.
But I understand. And keep in mind also that that is the subject of counts 4 and 5 of this information.
True.
So in and of itself, without additional evidence of what the appellant's intent was, and I also disagree with the court a little bit as to the timing issue, and that is based upon the motion that was filed, it's not really clear of the timing of when these photographs were sent. It was only with, again, the additional facts put forward by the assistant state attorney that the timing issue was addressed, or at least that's how I am reading things.
So help me out, Mr. Witt. So what, with respect to the oral traverse, what are you seeking this court to do? If we agree with you that this was problematic, what is the remedy?
Your Honor, the remedy is to vacate the conviction with respect to count 3, and then to remand the case, or to vacate the conviction altogether. Now,
To remand it and do what?
so keep in mind, there's, again, 2 aspects to this motion to dismiss. And so the second aspect is about the element of the offense, the age. If the court agreed with the appellant on that position, and we haven't had a chance to really talk about that yet, but if you agreed with me on that, then I think you're in a position to vacate that conviction entirely.
Is that a pure issue of law? In other words, do we need the state's traverse for that? The question is whether or not you can commit attempt with somebody who's not a minor, right?
It does seem like a pure issue of law, though there was a little bit of dispute perhaps as to at which point the different players were involved. But yes, I agree with you that it's primarily an issue of law.
Okay, so we don't need to resolve the oral traverse issue with respect to, at least to the age component.
Yes, sir. It would be more with respect to whether there was sufficient evidence of an overt act that the oral traverse becomes problematic.
Well, then, if that's true, why doesn't Hudson resolve this case?
So, certainly the argument is there that Hudson does, all right? But Hudson dealt with this idea of what is a legal impossibility. It did not at all address this circumstance of, is it an element of the offense? And that's why I asked the court to really look at the Palm Blanco decision, which used that analysis. And if the plain meaning of the statute is that this is an element of the offense, then I think the state has a problem here. And the statute, of course, is...
But is there a difference between attempt and solicitation that matters here? I mean, the court in Palm Blanco basically says, listen, solicit is victim-focused, right? And if the victim is not a minor, then you can't commit the crime of soliciting that minor lewdly and lasciviously, right? Intent on the other, or attempt on the other hand, is defendant focused, and it's focused on intent and overt act. And why couldn't you say, assuming the facts were there, why couldn't you say a defendant both intended to do lewd and lascivious with a minor and undertook an overt act in furtherance of that, even though he was communicating with an adult?
So I've thought about that issue a lot. I have 3 quick answers for you on that. First, attempt and solicitation are in the same Florida statute. And then secondly, if we look at the statute that he's alleged to have attempted to have violated, which is Florida Statute 800.04, the definition of victim is someone upon whom the offense was committed or attempted. So it's right there in the statute that the person... Well, then that's a separate section. But I was looking at the definition contained in 800.04 1 D. And then finally...
I think Judge Sleep was too, right? It is too.
Okay, you're right. Mm-hmm. You're right, Judge. I'm sorry.
So I guess the question is this. If Hudson holds that it's allowable to have a police decoy in order to prove an attempted lewd and lascivious battery, then why doesn't it apply to this particular case? Otherwise, it would be a legal impossibility to be convicted under this statute, given the type of investigations that occur.
I'd actually agree with you, Your Honor, that it should be impossible, because the statute itself actually requires that the offense be committed. and this offense was not committed. And if it's an element of the offense, and that was the contention of the appellant below, and it's our contention here, that you actually have to have a person under the age of 16. In a concurring opinion a few years back, they said, without an actual victim, the attempt statute can cover anything. And we can't have that in the criminal law. We can't interpret the attempt statute so broadly that it covers any and all scenarios.
So the fact that the law enforcement officer had the permission to use the minor's cell phone, and there's a question as to whether the minor and the parent were present when this particular text was sent to meet at Starbucks and also to provide us with a photo, you're saying that doesn't make a difference? Because I saw the court below was struggling with the issue with Mr. Britt about, well, okay, do I analyze the solicitation or the attempt related to the text between the minor, or do I analyze it in relation to the text between the law enforcement officer? So help me out.
So whatever happened with the minor was weeks before, and then by mutual consent of the parties, they apparently ended the communication. And it was later the law enforcement officer who renewed the communication. And then, Judge, it's not like the state doesn't have a remedy here. There are other crimes that were apparently committed, including the one contained in count 2 that we're not challenging before you. It's that this particular crime was not committed because that element was not present.
And Mr. Britt, you're into your butter time, but I'm going to give you extra time because I want you to address one thing that we haven't had a chance. The issue regarding the text, whether a text is an email communication.
And if I can add on to that, can you help me out with Simmons? That I think is, to me, the big issue there. I might, if I were writing on a clean slate, say you had a good argument, but I've got to deal with that case.
So, Your Honor, Simmons says that the only regulated method of transmission is email. Boom. I mean, it stops right there.
But it also talks about instant messaging, which seems awfully analogous to text.
So, words have meaning, and we all know what email is, but we also all know what instant messaging is.
Email is electronic communication. You'd agree with that?
Yes, ma'am.
All right. So texting is also electronic communication. You agree with that?
It's, okay, I'd probably be then a little bit more specific, Your Honor. Email is myself using my computer to, for instance, write to you.
No, not in this day and age. I have an Apple phone. The Apple phone, I could do it. Message, I could do an email on my phone itself.
And so, Your Honor, the legislature knows about texting. Now, maybe they didn't at the time that this statute was originally written, but in all of that, that's why I did in the brief, is pointed out all of the other statutes where they specifically addressed text messaging. And text messaging is simply different. We use phone numbers to text message, not email addresses. If presumably, Your Honor, if I send you an email, I know for a fact that it is going to you. Whereas if I text a phone number, I don't think that there's that same degree of certainty. I just think that there's quite a bit of differences.
I don't follow that.
All right.
Because email address versus phone number, we're talking about the electronic venue. And perhaps I'm seeing it more that you're trying to split hairs. What is an email? It is an electronic communication, and so is a text, especially in light of the Simmons case.
So if that was the definition in the statute, Your Honor, I'd agree with you. But when the statute says, for purposes of this section, this is how we're going to define transmit, then remember, this is the criminal law, and we have to really strictly construe criminal law statutes.
Yeah, but the other statute that you compare it to seems to give an exhaustive list of devices. This statute simply says electronic mail, which means that it's not so much focused on the device. It's focused on transmitting a harmful image to a minor. And the Supreme Court in Simmons adopted the definition of the first, which I think Simmons came out of the first DCA. And it's a pretty broad definition in terms of electronic mail being transmitted, sent to a specific individual known by the defendant to be a minor via electronic mail. It needs to be sent to a specific individual, must be specifically addressed to the individual, whether in instant messaging or emails sent and read at different times. Well, it seems to me that you can send the same type of substantial equivalent message via text that you can send by email. And I think common understanding is an email could be a little more formal and maybe a little more comprehensive just because it allows for more space and et cetera, et cetera. But you can text the same thing that you can send via email. And if I look at my iPhone today, I just noticed it because I was looking at iMessages. If I send a text, it says iMessage on it, which is an instant message, I presume. I'm just trying to look for the difference. I understand what you're saying about, but the common understanding is you don't really text a strange phone number.
I get strange text all the time. Well, and Your Honor, you're undergoing basically the same analysis that the judge did below. And I just suggest that it's perhaps flawed because the statute means what it says.
Well, listen, and I think, you can have a real argument about whether or not the kind of dictionary definition analysis that the First District in Simmons went through really reflects the plain meaning of the term. I get that. But the Supreme Court approved that opinion, so it seems to me that it's incumbent on you to kind of show us how the text is different from instant messaging in a way that changes the analysis. I just think that's kind of water under the bridge, maybe.
And really all I can offer you, Your Honor, is that text messaging was not at issue in Simmons, either at the appellate level or at the Florida Supreme Court level. I actually think Simmons predated texting. I've only started texting within the last few years myself, but there is something that is different about texting, and the legislature knows that because they specifically address texting in other statutes.
Thank you, Mr.
So I'll sit down
Bridge.
at this point. Thank you.
We appreciate it. We had you over, but I'll give you your rebuttal time, sir. Thank you.
Only if necessary, Judge.
All right. Thank you, sir.
Good morning.
Good morning, sir.
And may it please the court. Jason Miller for the appellee this morning. I would like to address, if I may, the points made by the appellant. Specifically, and I'll do it in the same order, changing it up from the brief itself. The first double jeopardy argument, generally we would ask to affirm or at least affirm the rulings in the lower court to the extent that an order from this court would be on an issue still relatively unsettled. Those two cases.
The argument, as I understand, the Supreme Court heard arguments in early June. Is that?
I believe December.
December.
And we're still waiting an order. I'm aware of Shelley and Sun Young Kim are the two from this court in conflict with Murphy. That's to the extent that that's not decided yet. I would ask to hold an abeyance pending that. And if it does come out in favor of Murphy, then we would ask obviously for a rejection of the argument by the appellant.
Or we could rule and you could seek a stay in the Supremes.
That's another approach. That's another approach, certainly.
Let's deal with the oral traverse, because that's troublesome.
Certainly, I would like to spend most of my time on the first two issues that were brought up. The first one being the sufficiency of the motions to dismiss, the second one being the statutory interpretation of transmit within the text message statute you were talking about. But first, I'd like to address both motions to dismiss. And I think the court is well versed on reading the motions themselves. I'd like to address specifically some terms that are in the motions, and I would like to expand on what the appellant actually discussed as facts contained within the motions, and make the argument that the motions themselves contained facts sufficient to deny the motions. As Judge Solaria was speaking about, not only does it in the latter paragraphs, I believe it's 13, 14, and 15, there are quotes specifically that The messages had a photograph. Those were deleted. The defendant was requested a picture of his penis, which he obliged, and then he traveled to meet. Those are specifically in the facts section. But we can also look to the argument section where facts are, again, alleged within the motion itself. Those were still sworn to as well. We need to consider those as facts alleged within the motions. We can look to pages on the record 54 and 55 for the first motion that's in the record, but also to 65, where the defendant alleges on record on 65, discusses the possibility of engaging in specific sexual acts. He asked the victim if she wanted to hook up. They discussed what's characterized by the defense as hypotheticals on what would occur should they ever meet and have the opportunity. They discussed a specific meeting location and a time. They then discussed with the decoy sexual acts to be committed and the location where they should meet. Those facts are right from the motion itself. Those facts support the charges against the defendant. And so the lower court properly dismissed, without really even getting to the traverse, but I do want to talk about it. Without getting to the traverse, we can look just to the motions themselves that they are insufficient in the sense that they contain facts for their own dismissal, that the state can use, plus any of the reasonable inferences from those facts that would support the case, support the charges of trial.
Was the charge of the lewd and lascivious, attempted lewd and lascivious battery based on the communications between the law enforcement officer, or were all of the communications?
Well, I believe it was all of the communications, but all of the communications that are contained within the motions.
Okay.
There is a discussion that appellant wants the court to look to the statements by the state attorney, but all of those statements are consistent with what's actually in the motions themselves. So another argument against the oral traverse is that it didn't add anything.
So basically, you're just saying we could ignore all that and just simply focus on the motion itself.
You can, but I also still want to talk about the legitimacy of the oral traverse, but I'll get to that in a minute.
All right.
But one thing I would like to address on Judge Sleet's question about the attempted L&L battery, not attempted sexual battery. So this is under 800, which conflicts with some of the cases, specifically Duke, which confounds L&L battery with sexual battery. This one is L&L battery, and we're talking about attempt. And we're talking about attempt and the elements of attempt, which are specific intent to commit a crime, and then an overt act toward the commission of that particular crime. Before I get to overt act, which I think is going to be another overture, I would like to address the oral traverse specifically. And there is an exception to the written requirement when, for a written traverse when the motions are untimely. It's mentioned in the brief, and the court in this case found very specifically that the motions to dismiss, both of them, were untimely, and said that.
Well, that's what initially when I was going through the sequence, take a moment. The position that they were untimely, when were they filed? What did the court indicate?
Sure.
And I know in the record, the state indicated that was not prepared, but just tell me specifically as to when the filing, the date specific for that.
What I can, from the judge's order, I can tell you that it was a pretrial motion deadline that expired, and they were not filed prior to that deadline. And I don't know the date, but I can tell from the context of the judge's order that that had expired. Then he filed them, I believe, on the end of January. The specific sequence is, I believe, the 28th and 31st, which I believe is a Wednesday and a Friday. Filed them both. Served the notice of one of those soon afterwards in that week. Both of them that week. So within less than 7 calendar days from the actual hearing, which was on February 4th, I believe, which is a Tuesday, was the first hearing on only one of the motions.
Well, defense counsel does concede that he served the notice of hearing on the same day.
The one of the motions was on the same
February
day.
4th.
The second one was on the second for 2 days later.
At the conclusion of the February 4th hearing, he indicates, I have another motion attacking count 3 also.
Correct, which he filed at the notice at 4:38 p.m. that same day of the first hearing. So after the first hearing, he notices the second hearing for 2 days later, giving less than 48 hours notice.
So you arguing that the court had discretion to allow the oral traverse?
Court had discretion for a number of reasons. First, that the court's own pretrial motion deadline had expired,
Okay.
which is involves the concept of notice. Secondly, they had less than 48 hours for which to prepare any kind of traverse or anything. And there's testimony from the state attorney that she physically didn't actually receive that second notice at any time. So she didn't even know it was on for that day. And there was a ruling that the judge found that they were not timely for any number of those two reasons. And because they're not timely, the judge has discretion to take an oral traverse at that time, which would be effectively the same thing as a written traverse. She's just swearing to it right there.
Yeah, I just haven't found a case on point. The cases that address oral traverses allow them when they're unobjected to. This was objected to.
Was objected.
But the question is, was it waived? Because the court did inform defense counsel, I am going to hear from the state regarding additional facts. And the defense counsel said, okay. But then subsequent to hearing those facts, he then objected to this oral traverse, and that's when the court said, well, let me put you under oath. Has what you just said,
right,
was it true? Sorry, is this a discretionary issue? Because, I mean, the rule does have a sentence in it. The court may receive evidence on any issue of fact necessary to the decision of the motion, but we can all interpret that to be testamentary evidence from a witness or someone else. It doesn't really seem to contemplate testimony from the state, because it then goes on to talk about having to file a traverse under oath.
Well, I think one of the analysis to look at here would be basically the notice requirement. Is putting it in writing going to change, and there's a prejudicial analysis, going to change anything in regard to what the other side would have done? Is there any information contained there that would have been a surprise in any way? Is there anything that wasn't contained in the oral traverse? Is there anything that wasn't contained in the record that wasn't shared with the defense that would have been a surprise? And there really isn't. There isn't anything indicated by the appellant that they've been prejudiced in any way. The objection, even at the trial level, wasn't, hey, this is a surprise to me, or I don't know what's going on. In fact, at the prior hearing, he was asking for a continuance, and so now he's not. So it seems like there might have been a little gamesmanship on trying to keep the state unprepared, which is exactly the point of the notice requirement, is allowing the parties to have their case prepared, have the judge be informed about what the facts are by whatever fair means necessary, so that the judge can actually make a decision on the merits themselves. And I think that's what eventually happened in this case, despite some alternative means, I suppose. But I don't think we necessarily have to get to the oral traverse, because there are multiple instances where it didn't add anything to what's actually contained in the four corners of the motions to dismiss, which support denial. The second point is in that subheading is the overt act issue, and I think it is a matter of strictly a matter of law, because if the issues are there, they're in writing by the appellant, by the defendant, then it's just a matter of determining whether that meets the legal burden of overt act. And I think it does in this case. There's a long line of cases that at a motion to dismiss, traveling with the specific intent constitutes the overt act. And it fits the definition specifically because it's the definition of attempt, because it's an act toward completion. It doesn't have to be the completion or an act within completion. An act within the element, which I think the appellant is urging this court to find that somehow the age is a necessary factor, or bringing along some other things which actually may go towards intent. The lower court indicated that flowers and chocolates and whatnot would be more along the lines of their specific intent versus any kind of overt act. Just traveling or being in the proximity. The Hudson case, the Meisner case, said it best, I think. But the defendant putting himself in the proximity of the victim had a realistic expectation of imminent contact.
Now, it's interesting because counsel, Mr. Bruce, raised the issue, the photograph.
Yes.
I think that you're taking the position the photograph was very explicit,
Yes.
When was that sent in relation to the traveling?
Well, I would say that is correct. There's nothing in the record to indicate when, other than being a day or so around the actual meeting time. There's nothing in the record to say he was on the way. There's nothing to say that he did it like this specific time in relation to the meeting. However, it is in a context that is in the four corners of the motion to dismiss.
Well, he was arrested at the meeting, right?
He was arrested at the meeting.
It had to have been before then.
Correct, but was it 5 minutes before or a day before? I think
a minute before?
Or a minute before. I think the record is silent on specifically then. And I think what his argument is that there may have been imminence that's inherent in the picture a day before. That's not an imminence at the meeting. But from the context of the language that's used within the four corners of the complaint, that's not necessarily the only fact of imminence that we have. We also have descriptions by the defendant in the motion itself that discuss the sexual acts to be committed at or very near the location where they were going to meet. When we meet, what are we going to do? We're going to do X, Y, and Z. Here's a picture of what I intend to do. And so just that picture tagged with that language speaks volumes about his specific intent upon meeting this decoy or meeting this child. So that's why I think the picture is relevant, because it does show specific intent, but tag it with the language, and it becomes abundantly clear. And the picture and the language both are within the motions to dismiss.
Could you please address the age element found in the Pamblico case?
Pamblanco, absolutely.
Pamblanco.
And I would like to make a point abundantly clear about that. Pamblanco dealt with solicitation, not the inchoate offense of solicitation. So to say that they're in the same statute is just not correct. Pamblanco dealt with solicitation under 847.0135. It's the same one as in this case, the solicitation to lure, entice, or attempt to seduce a child. So that's not the same as the inchoate offense of attempt or solicitation, which seems to be confounded. That is an affirmative element of the charge in Pamblanco. So it was required that the person be under 16 because that's one of the elements of that charge. In this case, the charge is attempt, not lewd and lascivious battery.
But can't you argue that you have the intent to engage, to at least intent to attempt to engage a minor 12 years of age but less than 16 in a sex act?
I hear that argument from the defense, but the element of attempt is not the element of the underlying crime. It's just the fact of the intent, specific intent to commit an underlying crime. And from the facts of within the motion, we can see that that intent is supported.
But if this went to a jury, you'd have the full and jury instructions. You'd have the jury instructed on attempt, but you'd also have them instructed as to the substantive charge, the substantive crime. Would you not? Well,
but I don't believe the substantive crime needs to be proven. Each element of the substantive crime, it needs to be proven. I don't think the instructions would indicate that not only does we have to prove the attempt of the substantive crime, we have to prove all of the elements of the substantive crime as well.
Well, can we draw a reasonable inference from this motion to dismiss both of them that refers to her as a minor, that she's under 16?
From the motion itself?
Yes, the four corners.
There's a discussion, yeah, absolutely.
Okay.
There's a discussion there's a discussion of her age. Let's see, one moment, please. I'm sorry, from the motion itself,
yes.
Regarding age, I don't see that in the motion itself. I'm looking at my notes from a subsequent filing. So it is discussed later, and my point with that would be that if it actually did go to trial, there would be testimony. There'd be more testimony than is required for the motion to dismiss to be presented at trial.
Well, here's another question.
So no, I don't see it. To answer your question, no, I don't see it.
When a court considers this C4 motion, can the court also consider the charging instrument? in making the determination as to whether there's a prima facie case. The charging instrument does specifically and expressly allege between the ages of 12 and 16.
It doesn't, but I don't think it has to.
Okay?
Because what's alleged here is the crime of attempt.
Okay.
And for a four corners analysis, it would be literally in the four corners. So to test the sufficiency of the motion, you'd look just to the motion. To test whether you, so I think the answer is you would look to the four corners, Your Honor.
Sounds like a no. Okay.
But a Pamblanco is distinguishable, number one, because it's a different statute. Number two, because the solicitation of a child is not to be confounded with solicitation in inchoate offense.
Well, it's interesting, Pablanco, that dealt with text messaging, which I thought was interesting.
Perfect segue, Your Honor. The next issue, the electronic mail, or the statutory interpretation issue, I'd like to say very simply, if I could, electronic mail, the two terms electronic mail are not the same as email. They're not the same thing, and they're not the same thing under statutes. Electronic mail, as it's defined, is defined differently as email, and even in the common understanding, they're different. And by definition of being different, one has to be more broad than the other one.
Well, I mean, I'll concede that if you did what the First District did and looked at the dictionary definition of mail, you could come up with an interpretation of electronic mail that's broad enough to embrace a text message. But is that really what ordinary people think about when they hear these terms? I mean, if I were to tell you I'm going to send you some electronic mail, would you be checking your text application?
Maybe not, but when we want to do a statutory interpretation, we would look first to the statute to see if it makes sense, and if in viewing the statute in the way that the appellant wishes the court to view it, it really just doesn't make any sense at all. And let me expand on what I mean by that. Specifically, appellant wishes to, what I understand appellant saying is that electronic mail means email. So if they're sending something by email and the exact same message by text, it's only a crime if you do it by email. The statute itself contains an exception at the bottom. The provisions of the section do not apply to subscription-based transmissions such as list service.
And for the record, you're making reference to 847-0138, correct?
Thank you, Your Honor. Yes, I am. 847.0138, the very last line, and it contains a definition of transmit containing specifically to electronic mail. Defendant is trying to say electronic mail means email.
But isn't there a classic email component of listservs? I mean, every listserv I think I belong to, bear in mind you're dealing with a Luddite here, so you may have to explain it to me, but I thought I get emails when I join those things. No?
I think you can, but my point is that electronic mail is more broad than email. So much more broad than the legislature, in their mind, when they defined electronic mail, they think that it could be confused with subscription-based transmission list servers to the fact that they have to put an exception in there to accept it out. In addition,
there are arguments you could make that cut both ways on that, though. I mean, in 2009, right, the legislature did the sexting statute, and that statute was specifically directed to activity that occurs by text messaging and uses a far broader definition than electronic mail does. I mean, it talks about images and information sent by any electronic means or something like that. So
okay.
When the legislature has targeted that specific activity, that is dissemination by text, it's talked about it differently, hasn't it?
Well, I didn't look specifically at the sexting language that you're talking about, but I will concede that definitions are in need of conglomeration. They're in need for a little clarity, and in finding that clarity, the first step to do would be to look specifically to this statute alone, and then subsequently, if it's not clear, then to go to other statutes. So before I get to that analysis, we can look to that exception. And the point I wish to make is that electronic mail is more broad than the common understanding of email, such that it could be confused with listservs, such that they have to have this exception. And we can also, in addition to that, we can look to another thing within this particular statute is the title. transmission of material harmful to minors to a minor by electronic device or equipment. So they're, again, expanding that definition to any kind of device or equipment. If it's to be understood, as the appellant urges, that electronic mail on any device or equipment is limited only to email, would be kind of a ludicrous understanding of the statute. That they meant to just mean email and not text message or Facebook message or any of the other instant messages that are possible. And that's where the Simmons case hit upon. They looked specifically at this and they said, well, it's got to mean instant message as well. Electronic mail doesn't exactly mean email in the same parlance. The statute directly in front of this one, 847.038, discusses email versus electronic mail, or at least they're in a long list of things indicating that they're different. And so there's a handful.
What do you say to your friend's argument that 0138 was part of the same enactment that contained 0137, and the definition of transmit in 0317 is substantially broader? And I'll just note as an aside, 0137 also contains the subscription-based transmission carve-out.
It does, and it also describes, if you're looking at the same type of description of terms, electronic mail is listed right next to email as well, to indicate that they're distinct, different entities.
You know, Mr. Miller, I'd let you also go
A little bit over.
to respond. I want to make sure that each of you have given an opportunity, but
Okay.
if you'd like to hit on an area that you have not discussed yet, feel free.
Really, that's just it. If I could just have one more minute on electronic mail not being the same as email. Smith discusses transmission, and I think talks exactly on that. The Smith case in defendant's reply brief discusses transmission under 847.0137, and also indicates that the definition of electronic mail isn't completely expansive. It's underneath, or at least smaller than the one in its compatriot 847.0137, and that it does not, or that it wouldn't contain deposits in a file sharing service, because that wouldn't be a dispatch. So I would ask this court to indicate that electronic mail, the way the appellant is asking this court to define it, couldn't be that narrow, but certainly it's not as broad as it's discussed in Smith, which is a much more expansive definition. But any affirmative dispatch to a specific individual using electronic means would be an excellent definition, I think, of electronic mail. Thank you.
Thank you, Mr. Miller. Mr. Bruges, would you like to have some rebuttal time?
Just very briefly.
All right, sir.
The only real disagreement I wanted to offer to the appellee is I don't see all of these facts in the motions themselves that he was arguing to you. If we look simply at the text of the motions to dismiss that were filed, they're not explicit at all as to what the actual conversations were between the parties, and that's why I don't think that there was a lot of evidence of intent below. And then finally, Judge, with respect to the issue of traverse, if you all remain interested in that issue, the Kalogaropoulos case from the Florida Supreme Court, I think, is the best discussion, and says that if the state wanted the court to rely on additional facts, they should have set those facts forth in a traverse, just as a non-movement would have done in a counter affidavit to defeat a motion for summary judgment. And I thought that language was helpful to explain a traverse. And with that, I very much appreciate all the work that you all did on this case.
Okay.
Thank you.
Thank you.
And thank you both, really well argued. And what we're going to do, since we've taken a little bit of time with that, the court will just take a 10